I'm Cynthia Rowland, and this is episode 49 of EO Radio Show. Today's episode summarizes the steps to winding up a charity that is a nonprofit corporation registered and operating in California. There are federal and state income tax considerations to address, as well as organizational formalities, which are slightly different depending on whether the charity is organized as a nonprofit public benefit corporation or a charitable trust. Our focus today is on the California Nonprofit Public Benefit Corporation that is registered with the California Attorney General's Registry of Charitable Trusts, and we're going to talk about the path it needs to take as it winds up and dissolves. Welcome to the EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. My name is Cynthia Rowland, and I'm a partner at Farella. I'm a business and tax lawyer with more than 30 years of experience advising clients on nonprofit and charity law. Through this podcast, our lawyers and guests will discuss a range of legal and business issues impacting the nonprofit world because we understand you work hard every day to make your community a better place to live and do business. Many of our programs focus on the basics, and at times we'll do a deep dive into narrow and complicated legal issues. Again, welcome to the EO Radio Show. We're glad you're here. In today's episode, I'll cover the steps generally necessary to wind up and dissolve a nonprofit charitable corporation that has been registered in California with the Registry of Charitable Trusts. For this discussion, I'm assuming that the organization is incorporated in California. There are nuances in each state that differ, and while many of the corporate dissolution steps that I'll talk about today are the same regardless of which state you're incorporated in, if the dissolving corporation is incorporated in a state other than California, be sure to check that state law, which will govern the specific details for terminating the corporation's existence there. So, thinking about California organizations. In California, dissolution of the California Nonprofit Corporation is intertwined with its withdrawal of its registration with the California Registry of Charitable Trusts. Similarly, withdrawal from the registry of a foreign nonprofit charitable corporation, that is, a corporation incorporated in one of those other states, and registered in California because it does business here, also has to involve itself with withdrawing from the registry. But I'm not going to go through the details specific there. It's very similar, but there are some nuanced differences. Then another thing to think about is the matter of the final tax filings with the Franchise Tax Board and the IRS. There's a bit of a loop there at the end for complicated organizations, since the final tax returns often can't be filed until the financial accounts are closed and all the assets are distributed. So some attention to the wind-up expense payments and wind-up cash and liquidation details will need to be considered as the organization nears the end of its intended final tax year. Another detail to note is that if the dissolving corporation is classified by the IRS as a private foundation, additional steps are needed to notify the IRS of the termination of private foundation status, which is not addressed in the final tax return filed with the IRS, nor is it automatic when the corporation dissolves. So with that overview, let's dive into the necessary steps when winding up a nonprofit public benefit corporation that's registered with the California Registry of Charitable Trusts. The first step is for the board to determine a plan of dissolution. Generally, this plan needs to address any issues related to terminating employees, making final contributions to the employee retirement plans, filing final employer tax returns, paying or providing for all known liabilities, notifying creditors, liquidating any assets that can be reduced to cash, and then deciding where those remaining cash and assets will go on final distribution. With regard to that final point, be sure to check the Articles of Incorporation to determine whether there are specific provisions for the transfer of assets on dissolution. By definition, since we are talking here about charitable corporations, the remaining assets on dissolution must be transferred to a charitable organization that meets the requirements of Internal Revenue Code Section 501c3. But there may be additional restrictions on what types of organizations are eligible to receive the remaining assets of the particular corporation in question. Once the basics of the plan of dissolution start to come into focus, it's important to analyze when the notice of the plan needs to be provided to the California Attorney General. Charities that are subject to regulation by the California Attorney General, which is basically all organizations doing business in California and which hold assets in charitable trust, are required to provide notice to the Attorney General before they sell, lease, convey, exchange, transfer, or otherwise dispose of all or substantially all of their charitable assets. Effective as of June 19, 2023, the phrase substantially all for these purposes is defined as assets equal to or exceeding 75% of all assets held. This rule applies not only to dispositions in the course of dissolution, but I mention it here for purposes of noting the issue in the context of dissolution. In other words, this rule applies whether the organization is dissolving or not, if it's going to dispose of substantially all of its assets. But of course, today's topic is the organization that's doing that as it's proceeding with its dissolution. The rule isn't clear as to what time period is relevant, though. For example, some organizations in their wind-up phase may plan the spend down over a period of many years, and it's not clear whether the AG notice needs to be given at the very beginning of the wind-up process or at such time as the board actually approves a disposition of 75% of the assets on a given date. Or otherwise, it's hard to know exactly what the AG means by that rule. As a practical matter, when I know that a California Charities board has a plan to dispose of 75% or more of their assets, regardless of the time period involved, we talk about the best approach to notifying the Attorney General's Registry of Charitable Trusts. So in that regard, you'll notice in the show notes that I have a link to the Attorney General's Office, California Department of Justice, General Guide for Dissolving a California Nonprofit Corporation. This PDF on the AG's website is described as their general guide for dissolving a California nonprofit corporation. There are a lot of exceptions and other things to keep in mind, but it's a good place to start when trying to understand the framework for winding up a California nonprofit. So once a California nonprofit corporation decides to wind up operations, it has to take these steps to dissolve and distribute the remaining assets. These steps apply after the nonprofit corporation's board of directors or its membership, which might be an additional step in the dissolution process, decides to cease operations, and the notice to the AG needs to be thought about before the remaining assets are distributed. So the process for winding up a nonprofit corporation in California, as I mentioned previously, involves not only the California Attorney General's Office, but also the Secretary of State and the California Franchise Tax Board and the Internal Revenue Service. So here are the basic steps. I'm not going to go through all the details of each step, but I'll give you some highlights to think about. First, as I mentioned, the nonprofit board or a majority of the corporation's membership has to approve the dissolution of the organization. Note, you may want to check the bylaws because for some organizations, there are special approvals required to dissolve. For example, a founder's approval might be required. Related nonprofit corporations may need to approve it as well. So anyway, the first step is to follow the procedures for that particular nonprofit corporation to approve the certificate of election to wind up and dissolve and to approve a certificate of dissolution. So part of this vote to dissolve will also include the approval of the plan of dissolution, which is, as I mentioned a little bit ago, addresses things like termination of employees and liquidating assets and things like that. So there's more to the plan than just a decision to wind up and dissolve. Step number 2 in the Attorney General's Guide is to file the final state tax return and verify the current status of the organization with the California Franchise Tax Board. Now, as I alluded to a little bit ago, there might be a bit of a catch-22 because you can't file the final California state tax return until you file the federal return. And for complex organizations, they may need to wait until later in the process to file these final tax returns. For example, if assets have to be liquidated, or, which is more often the case, if the organization has substantial interest-bearing bank accounts that are going to generate potential taxable income or other income that needs to be reported on a final Form 990. So you'll have to work with your accountant or your attorney to figure out when you file this final return. But what you do need to know when proceeding with the Attorney General's office is that the organization's status with the Franchise Tax Board is current. That is, that there aren't any late tax returns and that the organization is in compliance with the California Franchise Tax Board. So that's step number 2. Step number 3 for the California charity that's withdrawing from the Registry of Charitable Trusts and dissolving is to obtain the dissolution waiver from the Attorney General's office before disposing of the remaining assets. A nonprofit corporation that holds its assets in charitable trusts for specific purposes and activities as stated in the organization's articles of incorporation, has to follow those rules when winding up and dissolving, and the Attorney General's office will be very interested to make sure that the dissolving corporation, in fact, dissolves and distributes the trusts following the specific charitable purposes of the organization. Any transfer of the remaining assets that's inconsistent with the organization's stated charitable purpose may be subject to objections by the Attorney General's office. So that is why the nonprofit corporation has to request a dissolution waiver of objections from the Attorney General's Registry of Charitable Trusts. In requesting that waiver of objections, the dissolving charity sends a letter to the registry that has to contain all of the following information. First, a letter signed by an officer of the corporation detailing all individuals or groups who will be receiving the corporation's remaining assets. If no assets remain for distribution, that information still has to be provided in the letter. Typically, the AG wants to know where the assets were distributed. In the letter, each intended recipient has to include the following information: the recipient grantee's full name, address, and contact information, an itemized list of assets to be distributed to that nonprofit organization by type and value, the proposed date of the distribution to that charity, any restrictions on the use of the assets to be distributed, and the recipient grantee's articles of incorporation or charitable trust instrument. The communication to the Registry of Charitable Trusts also has to include a signed copy of the organization's certificate of dissolution that's been prepared and approved by the dissolving nonprofit corporation for submission to the California Secretary of State. And then finally, a copy of the corporation's most recent IRS Form 990, 990EZ, or 990PF for the last 3 fiscal years of the organization. There's special rules for nonprofit corporations that aren't required to file these forms. That's typically churches. But in any event, check the AG's guide for dissolution of a nonprofit corporation if those rules are relevant to you. And then finally, that letter needs to include an endorsed filed copy of the corporation's articles of incorporation, including any amendments, so that the registry reviewer can confirm that the proposed recipients of the assets on dissolution satisfy the charitable trust requirements of the corporation's articles of incorporation. Step number 4, once we've got our dissolution waiver from the AG, and by the way, that dissolution waiver takes at least 30 days and typically takes much longer, particularly if you're getting close to the end of the year. So if you want to file by December 31 and be dissolved, you'll want to be sure to file with the AG's office. If that date is really important, I would file by the end of September, early October, so that I would have the dissolution waiver by early December and can get the process completed. Filing that dissolution waiver in 30 days in advance is probably not going to allow you to dissolve by year end. And the reason I say that is that the Secretary of State's office will not file the certificate of dissolution unless it has a copy of the Attorney General's waiver of dissolution letter. So once the waiver of dissolution letter has come from the attorney, or technically the letter's called waiver of objection to dissolution from the Attorney General's office. Once you have that in hand, that is filed along with a certificate of dissolution with the Secretary of State's office. And then the time period for processing that depends on the time of year and how backed up the California Secretary of State's office is. But you will eventually get that certificate of dissolution file stamped back, and you'll know that you have dissolved as a corporation. The next step in the process is to submit that final certificate of dissolution as filed with the Attorney General's office. It's sent to the Registry of Charitable Trust Division. That final packet will contain a copy of the certificate of dissolution filed with the Secretary of State and the final financial report for the corporation showing that all assets were distributed properly, resulting in a zero asset balance for the organization. If not done already, it's noted above that this is the time to file the final tax returns, and they'll show a zero balance in all the financial accounts, and that will notify in those final returns, there's a box to check both on the Franchise Tax Board Form 199 and the various versions of the IRS Form 990. So that you check the box that this is the final tax return. Then for certain organizations that are private foundations, a final letter needs to be filed with the IRS that notifies the IRS of a voluntary termination of private foundation status. And that's an additional step, and one for which most organizations will need the assistance of their tax accountant or their tax lawyer. So I think that's enough for this episode. I hope that's a good overview for all of you of the withdrawal process for a California nonprofit public benefit corporation. Actually, other kinds of nonprofit corporations in California may hold assets in charitable trust, and they might be subject to similar rules. But in any event, that's a good overview. Be sure to check out the show notes for links to the AG's General Guide for Dissolving a California Nonprofit Corporation and some other helpful references to IRS website pages on these topics. I'm Cynthia Rowland, and you've been listening to EO Radio Show, your nonprofit legal resource, brought to you by the Exempt Organizations Group at Farella, Braun & Martel. If you have suggestions for topics you would like for us to discuss, please email us at eoradioshow@fbm.com. That's eoradioshow@fbm.com. Thank you for joining us. Until next time, make a difference.